Norton to identify himself under these circumstances. As we have discussed before here on ATA, courts have consistently recognized that filming in public is protected by the First Amendment. The Ninth Circuit Court of Appeals, which has jurisdiction over Washington State, recognized a quote-unquote First Amendment right to film matters of public interest in the 1995 case of Fordyce versus Seattle. The Ninth Circuit reaffirmed this right in the 2018 case of Askins versus U.S. Department of Homeland Security, stating that, quote, "The First Amendment protects the right to photograph and record matters of public interest. The government's ability to regulate speech in a traditional public forum, such as a street, sidewalk, or park, is sharply circumscribed. It is rare that a regulation restricting speech because of its content will ever be permissible. Therefore, it is likely that a court would determine that Mr. Norton's filming of the bank was protected by the First Amendment, and, because he was on a public sidewalk, it is highly improbable that a court would find that any restriction against filming the bank could be lawful. Still, it is important to note that in some circumstances, First Amendment protected activity can contribute to reasonable suspicion supporting a lawful detention. For instance, in the 2017 case of Turner versus Driver, the Fifth Circuit Court of Appeals granted qualified immunity to officers who conducted a Terry stop on an individual who was filming the quote-unquote routine activities of a police station from a public sidewalk across the street, despite the fact that the court recognized the existence of a First Amendment right to record the police in public.